Dear friends, as you all know, our Constitution of India begins with preamble. All these important features that we are going to discuss today are evolved directly or indirectly from those objectives that you can see in the preamble. So if you read preamble thoroughly, definitely it is easy for you to understand and remember all the features of Indian Constitution, and it is easy to connect the dots. Right? The Constitution has adopted many features from different countries, constitution across the world. But if you look at these features, once you go through these features, you realize how beautifully constitution makers have Indianized those ideas, understanding the needs of India. So if you're preparing for your semester exams, or if you're preparing for any other judicial services and UPSC, any other entrance or competitive exams, this one particular topic is really important to be prepared with: salient features of the Indian Constitution. So let us go through all the features one by one. Lengthiest written constitution. Constitutions are classified into two major types: written, unwritten. Right? For written, give me example: United States, and unwritten, England Constitution, right? Constitution of England. The Constitution of India is the lengthiest and detailed constitutional document in the world. Why we have so comprehensive and detailed constitution? Because our territory is big, right? That is one geographical factor. Also, we have diversity. We have different religious practices, culture, and different occupations, etc. So we need to manage everything. The influence of the Government of India Act of 1935, right? So huge part of 1935 Act we have adopted for the Constitution of India. We do not have different constitutions for state and central. That also one of the reasons for our constitution being so lengthy and comprehensive. The Constitution of India includes the fundamental principles of governance, also detailed administrative provisions. Both justiciable and non-justiciable rights are included in the Constitution. We know we are going to learn further more that adds up to this, right? So second important feature is we have drawn many different features from various sources. The Constitution of India has borrowed most of its provisions from the constitutions of various other countries, as well as from the Government of India Act of 1935. About 250 provisions of this particular act have been included in the Constitution. Dr. B.R. Ambedkar have clearly mentioned that the Constitution of India have been drafted after ransacking all the known constitutions of the world. Just imagine the effort gone behind this. Going through all the constitutions and trying to understand and jot on the points. It's really amazing. The structural part of the Constitution is to a large extent derived from the Government of India Act of 1935. And the philosophical part, fundamental rights and directive principles of state policy. This one, fundamental rights from American Constitution, and DPSP from Irish Constitution. And the principle of cabinet government and the relations between executive and the legislature have been majorly drawn from the British Constitution. So I'm also uploading one video where we discuss in detail various sources. I have already uploaded one where you have tips to remember various sources. So you can subscribe the channel so that upcoming sessions you don't miss. Unique blend of rigidity and flexibility. There are two classifications: rigid and flexible, right? A constitution may be called rigid or flexible on the basis of its amending procedure. A rigid constitution is one that requires a special procedure for its amendment, for example, the American Constitution, and a flexible constitution is one that can be amended in the same manner as the other any ordinary law are made, right? So for example, British Constitution. Our Indian Constitution is a unique blend of rigidity and flexibility. The Indian Constitution provides for 3 types of amendments, ranging from simple to most difficult procedures, depending on the nature of the amendment. So I'm going to upload one more small video on amendment procedures, 3 types of amendments, in detail. Federal system. Next feature, the Constitution of India establishes a federal system of government. Our government have all the regular features of the federation, such as 2 governments, division of powers, written constitution, the supremacy of the constitution, the rigidity of the constitution, independent judiciary, bicameralism. However, term federation nowhere used in our constitution. The Indian Constitution also contains unitary or non-federal features such as strong center, single constitution, appointment of state governor by the center, all India services, integrated judiciary. So you have these features also, which are features of unitary or non-federal features government system. So Article 1 of the Indian Constitution describes India as a union of states, which indicates 2 things. 1, Indian Federation is not the result of an agreement by the states, right? It is a union of states. No state has the right to withdraw formally from membership from the Federation. So any of the states like Andhra or, our Karnataka, we cannot tomorrow say that, I don't want to be part of this particular country. No state has the right to withdraw formally from membership from the Federation. Hence, the Indian Constitution has been variously described as federal in form, but unitary in spirit. Quasi-federal, that is how he calls, KCV calls this particular system, quasi-federal, right? So you may have question on this also. So this explanation is sufficient for that. Combination of parliamentary sovereignty and judicial supremacy. The doctrine of sovereignty of Parliament is inspired by the British Parliament, and the principle of judicial supremacy with that of this is from American Supreme Court. So Indian parliamentary system differs from the British system, and the scope of judicial review power of the Supreme Court in India is narrower compared to US. American Constitution provides for due process of law, and in India we have procedure established by law. Please read about this. Therefore, the framers of Indian Constitution had come up with proper combination between British principles of parliamentary sovereignty and the American principle of judicial supremacy. This one interesting thing, you just next point that I'm going to mention. Supreme Court can declare the parliamentary laws as unconstitutional through its power of judicial review. Supreme Court can declare the parliamentary laws as unconstitutional through its power of judicial review, and Parliament can amend the major portion of the Constitution through its constituent power, right? So Supreme Court can declare the parliamentary laws as unconstitutional through its power of judicial review, and Parliament can amend the major portion of the Constitution through its constituent power, right? So next, parliamentary form of government. The Constitution of India has opted for British parliamentary system of government. The parliamentary system is based on the principle of cooperation and coordination between the legislative and executive. The parliamentary system is also known as the Westminster model of government, responsible government, and cabinet government. The Constitution establishes the parliamentary system not only at the center, but also in the state. In a parliamentary system, the role of the Prime Minister is so important that the system is also called as Prime Ministerial government. And now you are seeing the importance or significance of that particular role in India, right? So next, one of my favorite features, rule of law. Law is the sovereign in democracy. The main ingredient of law is custom, which are practices and beliefs of as that we are practicing for very long period of years now. Rule of law means the sovereignty of the common people's collective belief, right? When there is a rule of law, there is no room for arbitrariness. Each individual enjoys some fundamental rights, and the highest judiciary is the final authority in maintaining the sanctity of the law of the land. That is Supreme Court. Highest judiciary is Supreme Court. The Constitution of India has incorporated this principle in Part 3, and in order to provide meaning to Article 14, which says all are equal before the law and all enjoy equal protection of laws. Right? So next, fundamental right. Part 3 of the Indian Constitution guarantees us 6 fundamental rights: right to equality, right to freedom, right against exploitation, right to freedom of religion, cultural and educational rights, right to constitutional remedies. The Constitution contains the basic principle that every individual is entitled to enjoy certain rights as a human being. The fundamental rights are meant for promoting the idea of political democracy. They operate as limitations on the tyranny of the executive and arbitrary laws of the legislature. They are justiciable in nature, right? This is important. Justiciable in nature, that means enforceable by the courts for their violation. I'll discuss fundamental rights in detail in my next sessions. Next feature, integrated and independent judiciary. India has a single integrated judicial system that we all know. Indian judiciary is independent and free from the influence of executive and the legislature. How far? But this is what, as our constitution says. The Supreme Court stands as the apex court of the judicial system. Apex court as the of the judicial system. Below the Supreme Court, you have high courts and at the state level. Under the high court, you have hierarchy of subordinate courts like district courts and lower courts. Supreme Court is a federal court, the highest court of appeal, the guarantor of the fundamental rights, and the guardian of the Constitution. Hence, the Constitution has made various provisions to ensure that judiciary be independent, right?